Good morning, ladies and gentlemen. Today, we are talking about Case 4 or the Augusto Benedicto Santos III versus Northwest Orient Airlines case. Let us now proceed to the facts of the case. The petitioner, Santos III, is a minor and is represented by his father. And the private respondent, Northwest Orient Airlines, is a foreign corporation with its principal office in Minnesota, USA, and is licensed to do business in the Philippines. And on October 21, 1986, the petitioner purchased a round-trip ticket from NOAA in San Francisco to Manila via Tokyo and back to San Francisco. December 20, 1986 was his scheduled date of departure to Tokyo. So on December 19, 1986, the petitioner checked at the NOAA counter at San Francisco Airport for his scheduled departure to Manila. But he was informed that he had no reservation for his flight from Tokyo to Manila. Due to this incident, the petitioner sued the airlines for damage at Makati Regional Trial Court on March 12, 1986. However, NOAA argued that the Philippines had no jurisdiction pursuant to Article 28 of the Warsaw Convention, which will be discussed later, and that the Philippines was not the carrier's domicile of business, pointing out that the petitioner's ticket was purchased in San Francisco, where the contract was made, and its final place of destination is San Francisco and not in Manila.
To continue, Petitioner Santos appeals that Article 28 of the Warsaw Convention is a venue provision and not jurisdictional provision. Therefore, it depends on the place of the incident and not just because of the scope of authority vested in the agency. Warsaw Convention is determined by the terms of the contract of carriage, which is the place of destination. The Warsaw Convention will be further elaborated in the following slides as we finish on the case. Meanwhile, the court has ruled that Manila should be therefore considered merely an agreed stopping place and not the destination of the petitioner. The lower court held in favor of the private respondent and was affirmed by the Court of Appeals. But Santos contends that the Philippines has jurisdiction over the matter since it was the place where the events have occurred or transpired.
For this case, we have two issues. The first issue is whether or not Article 28, Section 1 of the Warsaw Convention was constitutional. Under this issue, as we can see, the petitioner claims that the lower court made a mistake in not ruling that Article 28, Section 1 of the Warsaw Convention is inapplicable and that it violates the constitutional guarantees of due process and equal protection. The second issue is whether or not the Philippine court has the jurisdiction to conduct judicial review on the constitutionality of the case pursuant to Article 28, Section 1 of the Warsaw Convention. Under this issue, the petitioner claims that the lower court misjudged in not ruling that Article 28, Section 1 of the Warsaw Convention is a rule merely of venue and was waived by defendant when it did not move to dismiss on the ground of improper venue. To know the answers of these issues, let us move on.
Article 28, Paragraph 1 of the Warsaw Convention stated that an action for damage must be brought at the option of the plaintiff in the territory of one of the high contracting parties. It is either before the court of the domicile of the carrier of the principal place of business, or where he has place of business through which the contract has been made, or before the court at the place of destination. So to tackle the issue on whether or not the Warsaw Convention was constitutional, we must first understand its origin. So, the Philippines is a party to the Convention for the Unification of Rules relating to International Transportation by Air, otherwise known as the Warsaw Convention. So in summary, the Warsaw Convention is an international convention which regulates liability for international carriage of persons, luggage, or goods performed by aircraft for a ward. The convention is thus a treaty commitment voluntarily assumed by the Philippine government and as such has the force and effect of law in this country. The convention was concurred in by the Senate through its resolution number 19 on May 16, 1950. Excuse me. So the treaty was also a subject matter of disposition was a joint legislative executive act. The presumption is that it was first carefully studied and determined to be constitutional before it was adopted and given the force of law in this country. So therefore, the Warsaw Convention is constitutional.
Now, ladies and gentlemen, let us proceed on the rulings. So the first issue is that whether or not Article 28, Paragraph 1 of the Warsaw Convention is constitutional. Now, yes, ladies and gentlemen, the Warsaw Convention is therefore constitutional. Article 28, Paragraph 1 of the Geneva Convention states that an action for damage must be brought at the option of the plaintiff in the territory of one of the high contracting parties. It is either before the court of the domicile of the carrier or of his principal place of business, or where he has a place of business through which the contract has been made, or before the court at the place of destination. The Warsaw Convention, ladies and gentlemen, is a treaty commitment that is voluntarily assumed by the Philippine government and has the force and effect of law in our country. The convention, which is the subject matter of this petition, was a joint legislative act, ladies and gentlemen. So the presumption is that it was first carefully studied and determined to be constitutional before it was adopted and given the force of law in this country. The petitioner's allegations are not convincing enough to overcome this presumption. To further add this up, the petitioner had contended that Article 28, Paragraph 1 of the Warsaw Convention cannot be applied in the present case because it is unconstitutional, he says. He argues that there is no substantial distinction between a person who purchases a ticket in Manila and a person who purchases his ticket in San Francisco. The classification of the places in which actions for damages may be brought is arbitrary and irrational according to him, and thus violates the due process and equal protection clauses. However, ladies and gentlemen, take note that the petitioner's allegations are not convincing enough to overcome this presumption. Apparently, the convention considered the four places designated in Article 28 the most convenient forums for the litigation of any claim that may arise between the airline and its passenger, as distinguished from all other places, ladies and gentlemen. At any rate, the court had agreed that this case can be decided on the grounds without the necessity of resolving the constitutional issue. It is well settled that courts will assume jurisdiction over a constitutional question only if it is shown that the essential requisites of a judiciary inquiry into such question are first satisfied. There must be an actual case or controversy involving a conflict of legal rights susceptible of judicial determination. The constitutional question, ladies and gentlemen, must have been opportunely raised by the proper party, and the resolution of the question is unavoidably necessary to the decision of the case itself. Now, we will now proceed on one of Santos's grounds calling for the unconstitutionality of the convention, which is the rebus sic stantibus. So this will now then be discussed by Mr. Masque. So let's get it to go.
First, let us discuss the definition of the doctrine of rebus sic stantibus as defined by Jessup. It is a legal principle which would justify non-performance of a treaty obligation if the conditions under which the parties contracted have changed so materially and so unexpectedly as to create a situation in which the exaction of performance would be so unreasonable. In short, it is where a party may withdraw from or terminate the treaty in question. Santos argued in this case that the Warsaw Convention's stated provision, the Article 28, Section 1, was already utterly irrelevant. He claimed that the pact was no longer applicable due to major changes in the airline business over the years. He claimed that the provisions of the convention were meant to safeguard airline firms in the conditions that existed at the time the convention was signed in 1933, but that have since passed. Because as we can see, the conditions today and almost a century ago are indeed different. Even so, the Supreme Court still ruled in favor of the airline company, stating that this fact alone does not justify rejecting the treaty at this time. More significantly, the treaty has not been even rejected by the Philippine government, since it is not the court that has the power to reject a treaty, rather it is in the hands of the other branches of the government. The concept of rebus sic stantibus does not make a treaty ineffective automatically. A formal deed of rejection, normally made by the head of state rather than the court, is necessary, together with an explanation of the reasons why treaty conformance is no longer required.
Well, thank you very much, Mr. Masque. In addition, in line thereof, ladies and gentlemen, the treaty may be denounced even without an express justification for this action. Such denunciation is authorized under its Article 39 in the Convention for Unification of Certain Rules Relating to International Carriage by Air signed at Warsaw on October 12, 1929. Article 29, paragraph 1 states that any one of the high contracting parties may denounce this convention by a notification addressed to the government of the Republic of Poland, which shall at once inform the government of each of the high contracting parties. And that paragraph 2 states that denunciation shall take effect 6 months after the notification of denunciation and shall operate only as regards the party which shall have proceeded to denunciation. But still, ladies and gentlemen, obviously, the rejection of the treaty, whether on the ground of rebus sic stantibus or pursuant to Article 39, is not a function of the courts but of the other branches of the government. This is a political act. So the conclusion and renunciation of treaties is the prerogative of the political departments and may not be usurped by the judiciary.
Prior to the issue number 2, the Philippine court has no jurisdiction to conduct judicial review on the constitutionality of the case. The constitutional guarantee of access to courts refers only to courts with appropriate jurisdiction as defined by law. Courts will assume jurisdiction over a constitutional question only if it is shown that the essential requisite of a judicial inquiry involves conflict of legal rights. Susceptible of judicial determination, question must be raised by proper party, and the resolution of question is unavoidably necessary to the decision of the case. Petitioner cannot just go to any court for redress of grievances regardless of the nature of his claim, and consequently not deprived or denied by his right to access to court, but only because it was not vested with the appropriate jurisdiction under the Warsaw Convention, which is part of the law of our land. That's why Philippines is not a proper place for the petitioner to file his case. Jurisdiction in the international sense must be established in accordance with Article 28, Paragraph 1 of the Warsaw Convention, which is an action for damages must be brought at the option of the plaintiff in the territory of one of the high contracting parties, either before the court having jurisdiction, where the carrier is ordinarily resident, or his principal place of business, or has an establishment by which the contract has been made, or before the court having jurisdiction at the place of destination. following which jurisdiction of a particular court has jurisdiction to determine such subject matter, and that jurisdiction may not be conferred by consent or waiver upon courts which otherwise would have no jurisdiction over the subject matter. As to emphasis on rules as to jurisdiction, the domicile of the carrier is one of the places where the complaint is allowed to file an action as per by the article. As to proposed amendment, a citizen does not necessarily have the right to sue in his own court because the defendant airline has a place of business venue in its country. Wherefore, the petition is denied by the cause against the petitioner.